You all may be seated. Ms. Williamson, you brought this case before the court. What's going on?
Okay, so we're here today because we both have a child together and we both have split custody, but lately she has not been around. She has not been able to help me with the child. She's been doing her own thing and I need child support.
I've been working.
That's not an excuse. This is your child that you gave birth to, that I adopted, and I'm spending more time with her than you are.
Insurance. I got a lot to pay for. Help y'all out, take care of the baby. Just because I'm not around, that means I'm bringing in the money.
When's the last time you helped us?
Hello everyone, and welcome back to Judge Zone, your go-to channel for deep dives into the most intriguing courtroom cases and legal dramas. Today, we're diving into a wild and rather unconventional case from the courtroom of Judge Vunder. Grab your gaves and get ready, because we're reviewing the Williamson case number JVB 1050. This case is full of unexpected twists, quirky dialogue, and some hard-hitting realities about child support and parental responsibilities. Let's set the stage.
I understand your frustration, and I do have the court order that you provided, and it looks like child support was not ordered because you all agreed to have split custody.
Right.
Did.
Okay, so that's changed.
Yes.
All right. How long has this been going on?
For about now.
3 months?
That ain't easy.
Neither is mine, obviously, right? You'd agree that my job is not easy, right?
I mean, look
probably
pretty
not,
easy
right?
sitting down. I could do that all day.
Oh,
In this case, we have two moms, yes, you heard that right, both of whom shared legal responsibilities over a child named Sage, who is only 6 years old. One of the moms, Miss Williamson, brings this case before the court, claiming that despite the split custody agreement, her co-parent hasn't been contributing adequately to their child's support. According to Miss Williamson, she's carrying the lion's share of the financial burdens from insurance payments to everyday expenses like food, clothing, and general care. Meanwhile, the other parent, who legally adopted Sage, insists that she's fulfilling her responsibilities by working and providing for the child, even if that means not being physically present all the time. The dialogue in the courtroom is nothing short of theatrical. Judge Werby wastes no time in laying down the law, reminding everyone that while split custody can be agreed upon when circumstances change, the financial obligations may need to be revisited. We'll come back.
we'll come back to you, no worries. Now, she is working, you're having the child, I'm assuming almost 100% of the time?
Correct.
All right. You adopted the child?
Yes. I
Okay.
adopted the
How
child.
old is this child?
She's only 6.
6? What is her name?
Her name is.
Sage. Oh, she sounds so cute.
She is.
Now, is there anything else you wanted me to know before I move over to her?
Her reasoning when I asked her why she isn't spending amount of time that she's supposed to, since we do have split custody.
The case kicks off with the judge's official call to order. All rise. Judge Werby. Court is now in session, followed by a quick reminder of the case number JVB 1050. Right away, you can sense that this isn't your typical routine hearing. Miss Williamson steps up and makes her case. She claims that even though custody was split, her parent has been notably absent from the child's daily life. She argues that because she's shouldering most of the financial responsibilities, paying for insurance, ensuring the child has enough to eat, and even handling clothing needs, she deserves additional support. On the flip side, the opposing party retorts that being physically present isn't the only measure of parenting. In fact, the adoptive parent points out that she's been contributing by being the one who brings in the money. There's even a bit of a jab about who really carries the baby, with some humorous banter about carrying baby phenomenally, and even equipped that if a dog had a baby, the mother would be the one doing the carrying. This kind of colorful language might seem unorthodox, but it perfectly captures the high-stakes, high-emotion environment of the courtroom.
She's working, but when I go on her Snapchat and her Instagram, she's being flued out and in Miami, but yet you don't have time to spend with your child.
Why are you all on my social media anyways?
Ma'am, everybody is on your social media, okay? So let's not act like you don't know everybody is looking at social media.
Well,
And you being, what do you say, flued out?
Yeah, she's being flued out.
flew out for the week. No, I'm sorry. I'm be at work and it be a lot going on. Y'all know what I have to
So
deal
are
with
you
as a flight
working
attendant
when-
with all these crazy people on this.
Okay.
airplane.
Now, what really adds a contemporary twist to this case is the mention of social media. The judge hears that one of the parties is frequently flued out, a term that seems to be a playful modern way of saying that she's often away, perhaps on trips or social outings with her social media accounts, buzzing with activity. Snapchats and Instagram posts from Miami apparently paint a picture of a busy jet-setting lifestyle. This contrast is striking because while one parent is busy sharing her glamorous life online, the other is arguing that such absences are directly affecting her ability to provide consistent care for Sage. This element of social media intrusion into legal arguments is something we see more often these days. As personal lives become public, it raises interesting questions about modern custody agreements and whether digital presence should be considered when evaluating parental responsibility.
Are you being flued out with your job as a flight attendant, or are you doing other things that
I'm working
require
as
you
a
to be away
flight
from work?
attendant. Sometimes, occasionally, I may have a little flued out situation. But most of the time, I be working hard. I pay this $175 insurance. At least I'm doing
Congratulations.
something. I do
You pay a whole
$175.
$175 in health insurance.
What you mean?
What do you want for that?
Baby could be on Medicaid, but
Oh, you know what? That is a good point, but that's beside the point. At the end of the day, this is both.
Judge Werby doesn't let the theatrics distract from the hard facts. He digs into the financial details with precision. According to the documents presented in court, the parent in question earns about $79,000 a year. The judge then walks through the math from the gross income deductions, bring the net monthly income to approximately $5,151, with Sage being the only child in question. The calculated child support obligation comes out to roughly $1,314 per month, but the judge isn't done there. Recognizing that the parent is also paying for health insurance, a cost of $175, he makes sure to account for that credit, though it doesn't significantly alter the overall obligation. The blunt message from the bench is that financial support isn't optional, and that the numbers as laid out by the law must be followed. The judge makes it clear that regardless of personal disputes or social media antics, both parents are legally obligated to support their child.
So how much money do you make a year? And make sure you're being honest, because I have your documents in front of me.
about 79,000.
I couldn't hear you. $79,000 a year, and you want to be flued out and not give her anything for Sage? You came here to waste my time. I'm about to go ahead and read these numbers off to you so you can pay child support.
Child support?
Yes, ma'am. Child support. That's right.
I'm going to have to pay insurance too?
Yes,
You
ma'am.
need to?
Yes, ma'am. You're going to pay.
One of the most compelling aspects of this case is Judge Winder's no-nonsense approach throughout the proceedings. His language is direct and laced with both authority and a touch of humor. He criticizes the parties for wasting time and for any attempts to blur the lines of parental responsibility with social media status updates. His repeated emphasis on the word flued out, a playful yet pointed remark about being absent-minded or distracted, underscores his frustration with the deviations from what he sees as the court's clear mandate. The judge's delivery reminds us that while courtroom drama can sometimes resemble reality TV, the underlying issues are very serious. The care and support of a child like Sage cannot be compromised by personal disputes or a glamorous lifestyle. Judge Winder's firm stance serves as a reminder that the law exists to protect the welfare of the child, and that financial obligations are not a matter of personal convenience.
All right. How many children? Just Sage? Sage is the
Just
only
Sage.
child? Okay.
That I birthed for 9 months.
That you don't take care of?
You ain't carried for 9 months. What it is
Excuse
to carry
me.
a baby for 9
Okay,
months.
Just because a dog had a baby, that don't make it the mother.
Excuse me. I'm talking. I believe I'm the judge. You all do not need to address each other. You have enough issues as it is, okay? So,
That's why we ain't
again,
together now.
I
That's why I be
need
cheating now.
I need you to pay attention
Girl.
to the, since you like to be flued out and stuff, I need you to pay attention to these numbers as they fly your.
So what are the takeaways from the Williamson case? First, even in a situation where custody is split, the financial responsibilities associated with child support remain a non-negotiable part of parenting. The case highlights how changes in a parent's lifestyle, such as frequent absences or shifts in work schedules, do not automatically translate into a reduction of their legal obligations. In fact, when one parent ends up spending significantly more time with the child, as Miss Williamson argues, it's only fair that the other parent's contributions be recalibrated to reflect this imbalance. Moreover, the case sheds light on the evolving nature of modern parenting, where social media and digital lifestyles intersect with legal expectations. The courtroom becomes a stage not just for legal arguments, but for debates about what it means to be present and responsible in today's interconnected world.
Okay, so $5,157.12 is your net. One child, they bring your child support obligation to $1,031.42. Well, let me go ahead and give you a credit for that $175. It's not going to be much, so don't thank me yet. It's not. So let's see. I give you credit for the $175. 658. Oh yeah, that didn't really help you out none. So, I mean, your child support obligation is still going to be close to what I just told you.
In the end, Judge Winder's ruling was clear and uncompromising based on the financial evidence and the responsibilities of both parents. The child support obligation stands firm at just over $1,000 per month. The judge's decision underscores the principle that the welfare of the child is paramount, and that both biological and adoptive parents must contribute their fair share to support that welfare. As we reflect on this case, it's impossible not to be drawn in by the colorful dialogue and the high stakes involved. Whether you agree with the judge's decision or not, the Williamson case offers a glimpse into how traditional legal principles are applied in the modern era, where social media, lifestyle choices, and personal accountability all come under the microscope. Before we sign off, I'd love to hear your thoughts. Do you think the judge handled the situation fairly? What impact do you believe social media should have in custody and child support cases? Drop your comments below and let's get a discussion going. Thanks for tuning in to Judge Zone. If you enjoyed this review, be sure to subscribe and hit that notification bell so you never miss another deep dive into the world of courtroom drama. Till next time, remember, justice is not just served, it's reviewed, debated, and sometimes downright entertaining.
So $5,057.12, one child. Child support obligation is $1,011.
A month?
That's what I said.
$1,000?
Yes, ma'am. $1,000.
That's a whole rent payment.
You got it.
That's what I'm saying. You got it.
You got it. You being flued out.
Did you get what I just said? You got
I heard you.
Oh, okay. Is there anything further?
No.
All right. Did you have anything further?
No, thank you.
You're welcome. You all are dismissed.